How to reunite your parents in Spain? How to bring your parents to live with you in Spain? That's exactly what we're going to discuss in today's video. Make yourself comfortable, let's get started. The answer to this question will depend on who you are and what rights you have to stay in Spain. Basically, whether you have a residence permit in Spain or if you have Spanish nationality. Let's start with the simplest scenario, which is if you have Spanish nationality. And then we'll talk about how the process is to reunite your parents if you don't have Spanish nationality. First of all, sorry for my voice, I'm a bit under the weather, so there might be some voice cracks, some strange, odd, uncomfortable sounds. I'm sorry, but I try not to miss the commitment and publish at least one video daily. So that's why I'm here giving it my all, even if my throat is full of mucus. As I was saying, let's start with the procedure for reuniting your parents if you are Spanish. Under the current regulations, we are in March 2025. You would need to use a figure called arraigo familiar with the arraigo familiar. You or as a Spaniard can reunite your parents over 65 years old very easily, simply by proving that they are registered at the same address. Therefore, you already know that your parents would need to be in Spain, proving that and proving the relationship with you. And that they do not have any criminal or police records, basically just that. You can already grant your parents a residence and work permit for up to 5 years, which is essentially a family reunification for parents, but the figure is not called that. If you are Spanish, as of today, March 2025, it is not called that. It is called family roots. And after May 2025, it will be called a residence permit for people with Spanish nationality. And after May 2025, specifically on May 20th, it will be called a permit for relatives of people with Spanish nationality. So, we have a first conclusion. If you are Spanish, and that is to reunite your parents over 65 years old. It will be extremely simple, just prove the relationship, that they have no criminal record, and that they are registered together. Now, what about parents under 65 years old? Well, for them it will be a bit more complicated as you will have to prove that these parents are financially dependent on you. So, you can do that. Again, the requirement of being registered together is needed. And the issue of financial dependency can be proven, well, with money transfers that you have regularly made to your parents' country of origin or wherever they lived before, showing that you sent money to both or to the one you wish to reunite with in sufficient amounts for them to subsist. And that is usually enough. Or if the father is in Spain, well, that he has been registered with you, and therefore it could be assumed that you provide for his sustenance because he has been registered with you. In any case, we always recommend complementing the situation of joint registration, even if it has been for several months before making the application, with proof of money transfers to the country of origin. This regulation will change starting from May 2025. I have said everything I have explained so far is with the current regulations, which are in effect until May 20th, 2025. From then on, we have the new immigration regulation, the new immigration law, as some know it, and there the requirements change. They change in the sense that the age is increased, from which one must prove economic dependency. It will no longer be for those under 65 years old, but for those under 80 years old, which makes obtaining this authorization more complicated. If your father is between 65 and 80, then definitely it will be much more favorable for him to make his application to carry out his reunification process now, before May 20th, 2025, rather than waiting to do it afterward, because as I said, they will require economic dependency for people up to 80 years old. For those 80 years and older, it will be the same as it is now for people 65 years and older. Therefore, the process will become more restrictive. If you are in this situation, we strongly encourage you to do it now. Do the reunification before May 20th, 2025. As you have seen from what I have mentioned, the current process, which will be in effect until May 20th, requires that you are registered at the same address as your father in all cases. This means that the application can only be made from Spain. Your father, to enter Spain, would have to do so either as a tourist or with another type of visa, but not for family roots, because there is no family roots visa. The most similar would be a community card visa, but there he would have to prove things like economic dependency at any age of the father, which is not usually the case with family roots. So in most of our cases, as long as they are countries exempt from short-term visas, duration to enter the Schengen area, we usually recommend entering as a tourist and doing the family reunification process here, which is completely legal under Spanish regulations. That is another thing that changes with the new immigration regulations, as the application can no longer be made from Spain. There is an advantage, which is that it can be done while the parent is outside of Spain on a Malam. It will be possible to process this at the consulates. The same provision contemplated by Spanish regulations can be requested from abroad. This currently does not happen because you cannot request family roots from outside. With the new immigration regulations, it will happen, but the possibility of requesting it for parents who are already in Spain is removed. So, it's a trade-off. There is a disadvantage for an advantage, and in many cases, it is an important advantage. If your father is currently in Spain, because if you go past May 20th without having requested his reunification, well, you should know that you will no longer be able to request it. Basically, he will have to leave Spain to be able to request it. So, there's another reason for you to hurry and do the reunification before May 20th, 2025. Remember, any concerns? You can leave them in the comments if it's a specific question, or if you want us to evaluate your case and outline the best path to your legal residency, or your father's, or your nationality, or your father's. So, in the pinned comment, you have a link. There you can schedule a consultation with me or a member of my team. Or also in the description of this video, you have a link to schedule a consultation or to contact us through our contact methods. You contact us and we schedule that consultation for you. Most of these consultations are free. So take advantage, and now let's move on to the second part of the video. How to reunite your parents if you only have legal residency? Well, the first thing you need to know is that generally a legal resident cannot reunite parents in Spain, and there is only one exception to that rule. And that is if you are a long-term resident, what they used to call permanent residents. The person who has this card, which is a general regime card valid for 5 years stating long-term residency on the back, if you have this card then you can reunite parents, but not just any. They must be parents over 65 years old, and only if you can prove that their economic support depends on you, that they are financially dependent on you, and that they need your help. Because there is no one else who can provide it to them, nor can they themselves, because they have no assets, properties, income, pensions, or any other obligated family member. So then, it's up to you. You can prove that economic dependency, you can prove that they have a material need for help, and then it would be a viable process, solely and exclusively if you have long-term residency. If you are another type of legal resident, a temporary resident, then no, you would not be able to access this reunification figure. So there we have one more reason to obtain your Spanish nationality, as it will surely not only grant you many rights that you can enjoy, not just for yourself, but also rights for your family members, such as, in this case, for your parents, where it is substantially easier for them to obtain their residence authorization in Spain. If you are Spanish, even if you are not Spanish, if you only have a residence authorization, substantially easier for Spaniards. Remember, obtaining nationality is very simple for Latin Americans. Only 2 years for those married to Spaniards. Only 1 year for those from Andorra, the Philippines, Equatorial Guinea, and people of Sephardic origin. Only 2 years as well, like for Latin Americans, for the rest of the people, 10 years. Continuous legal residence immediately prior to the application. Applications take between 4 and 5 months as of today. And if you want us to help you with that, link in the pinned comment, schedules or advice, most of them are free. Finally, remember our satisfaction guarantee, according to which, if you do not obtain your legal residence, if you do not obtain your nationality, you do not pay us. A cent applies under terms and conditions. Consult with your advisor on the day of the consultation, but it usually works in the way I just mentioned. Thank you so much for your comment. Share this with anyone you think it might help, and for subscribing above all. 1,000 thanks. Until next time.